Yes, good morning to all. Today we are going to discuss that is buyers are filing a writ petition challenging the MSME award without using the normal procedure under Arbitration Act, prescribed in the Arbitration Act. See, certain occasions only the writ petition is acceptable. For example, if the MSME commits any procedure lapses, there is a procedure lapses in the MSME, like without going for conciliation, they have taken up the matter for arbitration directly, and they have passed the award, and they have not accepted any counter reply, or they have not provided any opportunities for the opposite parties. Then, in those circumstances, there is any procedure is not properly followed, then writ petitions file can be acceptable. But for bypassing the Arbitration Act procedures and directly filing writ petition before the High Court for not avoiding the deposits, paying the deposits, writ petition is not at all acceptable. So let us see what the case is. That in this case, the same thing is happened, that the supplier filed a case before the MSME Council, and Council during the COVID time, they have provided the time for reply, and the respondents, that is buyer, also filed their counter reply, and they have not appeared further and made their arguments. So what happened is award was passed, and only when the recovery order is filed is before this court, the buyer comes to know that the award was passed against him, and he filed a writ petition directly before the High Court. The High Court, after hearing, has passed an order stating that you should not file a writ petition challenge the arbitral award. The procedure is already prescribed well in the Arbitration Conciliation Act. You should follow the Arbitration Conciliation Act. Even when the time is expired, you should have filed a petition for condonation of delay and also make an appeal. So that is the procedure, and file making a deposit of 45% of the award amount. Without doing so, they cannot directly challenge the MSME award. So this is the order passed in this matter. Let us see what the case is now. So it is a case between Sambhav Engineering Limited, Ahmedabad versus Uttar Pradesh State MSc Council. The observation is that arbitral award under MSME Act must be challenged under Section 19 of MSME Act, read with Section 34 of the Arbitration Act, and not by a way of writ petition. You have to see that this appeal must be challenged under the Arbitration Act, because award is passed under the Arbitration and Conciliation Act by the MSME and not by way of any other order. So that is to be followed. Due procedure is followed under the Arbitration Act only. The petitioner entered into a contract with the respondent company, Ms. High-Tech Concrete Limited. Both companies are said to be registered under the Micro, Small and Medium Enterprises Development Act 2006. When a dispute arose between the parties, they are referred to conciliation. However, due to failure of conciliation proceedings, the parties were referred for arbitration as per Section 18 of MSMED Act. The petitioner stated that it had appeared in the arbitration proceedings and also filed objections to the claim preferred by respondent number 2. However, due to COVID-19, petition could not appear through thereafter, and award was passed on 23/3/2021. The petitioner came to know of the award only when the recovery proceedings were initiated against it in November 2022. Subsequently, petitioner filed a writ petition challenging the arbitral award. The Council for Respondent raised an objection regarding the maintainability of the writ petition in the view of alternate remedy provided under Section 19 of MSMED Act. For challenging the award, it must be submitted that arbitral award must be challenged under Section 34 of the Arbitration and Conciliation Act 1996. Further, it was argued that the dispute between the parties was private in nature, thus not amenable to jurisdiction of the High Court. The reference was made to the decision of Supreme Court in Bhavan Construction versus Sardar Sarovar Narmada Nigam Limited, where an award passed under Section 16 of the Act of 1996 was challenged in the risk jurisdiction of High Court under Article 226 and 227 of the Constitution of India. The Supreme Court had held that it is therefore prudent for a judge to scroll down to not exercise discretion to allow judicial interference beyond the procedure established under the enactment. The power needs to be exercised in exceptional rarity wherein one party is left remediless under the statute, or clear and bad faith shown by one of the parties. So this is a very important point you have to note. This writ jurisdiction, the challenging of arbitral award, is used only in an exceptional exceptional rarity, where one party is left remediless under the statute or a clear bad faith shown by one of the parties. This is very important. Otherwise, a writ petition cannot be accepted. This High Court this high standard set by this court in terms of the legislative intention to make the arbitration fair and efficient. Let's come down. The court observed that under Section 34 of the Arbitration and Conciliation Act 1996, read with Section 19 of the MSME Act, petitioner has a remedy to raise all grievances raised in the petition. So, yes, all the procedure, that is, all the grievances you can raise through the Arbitration Act, not by way of writ petition. Arbitration Conciliation Act has that provisions. The court observed that it is noticed that even as per Section 36, it is provided that where the time for making an application set aside the award under Section 34 of the Arbitration Conciliation has expired, then subject to provisions of subsection 2, such awards will be enforced in accordance with the provisions of CPC. That is Civil Procedure Code in the same manner as if it was a degree of court. The court held that award must be challenged within time specified in Section 36 of the Arbitration Act 1996. The court held that the mandatory time period within which the award is to be challenged had expired. While dismissing the petition, the court further held that writ petition is maintainable against an arbitral award and dispute between the parties. The Allahabad High Court has held that an arbitral award passed in reference made in Section 18 of the MSME Act must be challenged as per provisions of Section 19 of the MSME Act, read with Section 34 of the Arbitration Conciliation Act 1996. Section 19 of MSME Act provides an application for setting assets and degree award or other order made either by the council itself or by an institution or center providing ADR services to which a reference is made by the council under the MSME Act. This shall not be entertained by any court unless the appellant, not the supplier, deposits 75% of the decretal amount. So the 75% of the decretal amount is to be paid only by the buyer, not by the supplier against the award. Okay. So it is very clear. What you have to advise to our client is that in case if they want to challenge the petition, they have to file under the Arbitration and Conciliation Act an appeal before the High Court, not by way of filing a writ petition. Writ petitions is rare and rare occasions only to be accepted. That is, I already told you that where the due procedure is not followed. For example, firstly, if you go to the MSME Act, the first thing is conciliation proceedings will take place. Conciliation fails, then arbitration starts. Without going for a conciliation, if the MSC Council straight away go to the arbitration and pass the award, then you can file a writ petition stating that they have not followed the law. Okay. If they followed the procedure, conciliation, they have given a time for conciliation, both the parties come together, amicably settle the matter, all the chances were given, but no conciliation is failed. They are not ready to amicably settle the matter. They want to contest the matter. Then it will be referred to the arbitration, either by its own or it can refer the matter to any arbitration center. But in that arbitration also the buyer fails. His petition is, that is his counter reply has failed. Award is passed against him. He has to follow the procedure as per Section 36 of the Arbitration Act, where the time period is given. He has to make an appeal before the High Court by depositing the amount of 75% of the award amount, and he has to make an appeal to the High Court showing that I have deposited 75% of the amount, I want to challenge. In case he is not able to file an appeal within a time, then also he can file an appeal before the High Court. Two petitions has to be filed. I think the one is to be for condonation of delay in filing the petition in time, and second one is the appeal. Firstly, time should be condoned. Okay, you are filed belatedly. What is the reason? This is the reason. So you should show a sufficient cost to the court. Yes, the matter it is condoned. Now we will take up the matter for appeal. Before taking the matter for appeal, the court will see whether you have deposited the 75% of the amount. Yes, you have to show a proof that I have deposited the 75% of the award amount. Then the matter will be taken up and your appeal will be proceeded. Okay. So you understand the process. What is the process? This is the process. Any doubt on this, you can ask to me.
No,
Sir,
sir. Okay.
I have a doubt.
Yes.
Sir, which writ petition is filed? There are 5 writ petitions.
What?
Which writ petition is filed in case due process is not followed?
See, writ petition, it is only writ petition civil. That's it. It's a writ petition civil. Challenging the arbitral award. That's it.
These are different from habeas corpus and
See, there are 5 types of writ petitions. You are speaking about the in Constitution of India, habeas corpus, writ of certiorari, writ of prohibition, writ of mandamus, right? Another one writ petition, writ of quo warranto. Writ of habeas corpus is only an individual can file if a spouse or his son or his relative, his close relative, is been taken to police station but is not found where he is. His son have a body of persons to be presented. The court will order the police officer to bring that person before 24 hours in the court. That is called as an writ of habeas corpus. Writ of prohibition means the court which is exercising its jurisdiction is not exercised that within its jurisdiction. It is gone beyond its jurisdiction. The court will pass a prohibition order. You should not pass these kinds of orders which you have no power to do that. For example, small causes court have only jurisdiction of 5,000 rupees. It cannot take up the cases where the punishable offence is more than 1 lakh 5,000 rupees. Writ of certiorari means where the court takes a case where it has no jurisdiction, whether it's a pecuniary jurisdiction or territorial jurisdiction. It has no jurisdiction. It's taking writ of certiorari. Writ of quo warranto means on what authority a person is holding in public office. You can file a writ petition. That person is sitting in a public office, which only an elected persons can go and sit there and pass the orders. Okay, but in what authority is sitting there if he is not an elected person? For example, I am telling you. Without being statutorily appointed, he is sitting in a public office. It's called a quo warranto. Okay. So, writ of mandamus. Writ of mandamus is the writ where if a statutory body is required to do its duty, but it is not doing its duty. Okay, then you file a writ petition to command. This is called as a mandamus. Okay. For example, corporation has to issue a birth and death certificates. It is not issuing it. Applied for so many number of times. It is not doing the duty at all. It has to clear the garbages every day, but it is not doing it. Whatever authority with best with that public office peoples or government bodies, they are not doing it, which is statutorily required to be done by them, but they are not doing it, then you file a writ petition before the court and stating that, sir, they are not doing the duty properly. See their lapses, they are not doing it. Even the authority vests with them. Then a command will be passed by the court that do your duty. This is called as writ of mandamus. Have you any doubt? This is different. This is different. And these writ petitions are different.
Okay, sir.
Any
Thank you
doubt?
so much.
Clear?
Yes, absolutely.
Thank you.
Thank you, sir.
Thank
Thank
you, sir.
you all.
Thank you,
Thank you,
sir.
sir.
Thank you so much. Thank you.